Welcome back, everyone. Today's story is about a self-proclaimed sovereign citizen who makes the bold decision to go head-to-head with a judge who clearly isn't in the mood for games. There's no need for a long introduction or setup, so let's dive straight into it.
Good afternoon. All right, we are on the record in the matter of People versus Latavius Treshad Thornton. This is case 25-203-FY, and may I have appearances for the record, please?
George and on behalf of the people, Your Honor.
Thank you, and?
I'm Melissa Vachon with the Office of the Public Defender, Your Honor. I would note for the record that I am present and I did speak with Mr. Thornton. However, he is declining my representation at this arraignment.
Okay, and Mr. Thornton, could you state your name for the record, please?
I will object to being called Mr. Thornton. I am, for the record, my name is Shoulders. I am here as legal representation for Latavius Treshad Thornton, which is a nonprofit organization.
Your Honor, I'm looking at his file from 2022. I think he was sent to competency back in 2022, and it looks like it's going to be the same issue today. It's my understanding that he might have a bench warrant out for his arrest for sentencing. He pled guilty to, I believe, attempted R&O in November 8th of 2022, but he failed to appear in December 2022. And looking earlier in the files, I believe he was sent to competency as well. And it looks like this is going to be the same issue. So if the court is inclined to send him to competency, I'd ask for that.
Objection again, Your Honor.
Everything comes through me. You're going to get your turn, okay? But I have to run this in sort of an organized fashion, in part for you, because if you want to appeal, you want a transcript that is coherent and readable, okay?
I'm sorry. I don't know. Were you speaking to me or
yes,
to
sir,
Mr. A?
Mr. Thornton. So if you want to appeal,
I just want the record to be correct, and there was no objection. There was no objection to the statement that I made about Mr. Thornton, about Latavius Treshad Thornton being a nonprofit organization, and I was just objecting the points that the attorney prosecutor made.
Okay. But yes, there aren't objections at arraignment. There aren't objections at arraignment. And I am going to call you Mr. Thornton because that is the name that you have been identified as, and that is the name the charges are under. No, Mr. Thornton. So, I mean, the other option is to call you defendant, which is true. You are the person defending yourself, but that sounds kind of rude. So I'd rather call you Mr. Thornton.
It may sound harsh, but it's the truth. The court has already addressed him by his full legal name, the very name given to him by his own mother. But even that failed to move the situation forward or make any difference.
So I want to make sure that we treat you with as much respect. Here's why we have this hearing. You have, under the Constitution, a Sixth Amendment right to know the charges against you. So we have this hearing for that reason. So I want to make sure that you get all of your rights and know everything that is available to know about this case right now so you can defend yourself. That's the whole purpose today. To give you the information you need so you can defend yourself with or without counsel as you wish, okay? We're going to do 5 things this afternoon. First, I'm going to read the charges against you, including the maximum possible penalties, because you have a right to know them. Second, we're going to talk more about your rights. Then, I'm going to enter a not guilty plea on your behalf. I'll give you the opportunity. No, sir. So just a minute. Okay, so you're going to have the opportunity. You can stand mute or plead not guilty. We'll come to that in a minute, okay? So that's the third thing we're going to do. Then we're going to talk about dates when you return to court. You're going to get those in writing. Lastly, we're going to talk about bond or bail, okay? So,
can I please?
Because here's the thing: I don't want to be disrespectful to you.
Right, absolutely.
I know it feels disrespectful, but here's why. Here's my concern. I don't want you to say anything that could come back to haunt you later. So that's why, and this is true of every arraignment I do, I tell people right at the beginning, if you try to speak, I'm going to shut you down. And it's not to be disrespectful, and it's not because the case has already been decided. It's to protect your innocence and your interest going forward. So for that reason, I'm going to do most of the talking here.
That's fine, Your Honor. I'm
Okay,
fine with you doing most of it. But please, to protect my free speech, could you please not mute me? I have no intentions of disrespecting your courtroom. If I speak out of turn, could you just simply let me know?
The irony is hard to miss. He spends his time lecturing the courtroom on how things should be done, yet he's the one constantly interrupting and breaking the very rules he insists on. And let's be clear, freedom of speech doesn't give anyone the right to disrupt court proceedings whenever they feel like it. Most people understand that. In his case, though, those grand speeches aren't being made from a position of power. They're being delivered from inside a jail cell.
And I am aware that I am innocent until proven guilty, and that something I say could, like you said, come back and haunt me. I'm well aware of that, fully Taylor Strayshot Thornton. However, I do still need to express correctly, and if I'm capable of settling this matter now, why can't we do that? I have more than just the Sixth Amendment right. I have a plethora of rights that are granted to me from God, the Human Declaration, from the Constitution, and so forth. There's a plethora of rights that have been granted onto me. So I don't just want to rely on the few far in between. I would like to rely on all my rights and abilities, and if possible, take care of all these matters in the most dignified and respectful way to keep the court's dignity and my dignity as a man. And furthermore, as a preservation of my innocence, I would like, until proven guilty, I believe that is pertinent that the innocent factor be imminent here.
Absolutely. So here's what I'm going to tell you. And I tell this to everyone at this stage. The most important thing I can tell you this afternoon is that you are innocent. You are innocent unless you remain innocent, unless at some point you plead guilty or are found guilty beyond a reasonable doubt at trial. And I say unless for a reason, because it's different than until. Until means something's going to happen sooner or later, right? We'll be here until Saturday. Saturday is going to happen. Unless means we don't know what's going to happen. And in your case, we don't know what's going to happen. You haven't seen the evidence. Okay, I'm going to keep going through this, and then I'll acknowledge you in just a minute. You haven't seen the evidence.
Okay.
No attorney has seen the evidence. The court hasn't seen the evidence. So you remain innocent unless you plead guilty or are found guilty beyond a reasonable doubt at trial. And now I'm going to read the charges against you because you have a right to know them. Okay? You can't really defend yourself unless you know what you're accused of. Maybe you remember being a little kid and going to the principal's office and not knowing what you might be in trouble for.
I wasn't in trouble.
No? Okay. Well, you were probably a better little kid than I was. But I'm going to read the charges against you. It's going to take some time reading all the way through them.
Before you get to reading, can I make one statement, please?
Well,
Your Honor?
You can, but let me read through these first, okay? Let me read through these first because I want to make sure I cover everything. The other thing is judges use scripts. And the reason we use scripts is to make sure everyone gets all of the information and to make sure we treat everyone the same.
I'm aware of that, Your Honor. And that is why I feel it necessary for me to make certain things known for Taylor Strayshot Thornton, for that the script so we can stay in honor. Once again, I have no intentions on dishonoring the courts. I'm even here to surrender all of the interests of Taylor Strayshot Thornton to the courts. I have those full intentions. And so that you guys can be safe from all liability of Latavius Treshaw Thornton as his representation. That is the only reason why I speak in the way of please refrain from calling me Mr. Thornton and certain things, because it's pertinent for you guys to know I've already been treated as the surety. I am not the surety. I'm really Shoulders. Like, if you guys meet my people, you will find out I'm really Shoulders.
By now, everyone's heard the nickname his buddies use for him, Shoulders. And honestly, it seems fitting, because one thing's for sure, nobody's calling him brain cells.
Latavius Treshaw Thornton is really a nonprofit organization, and I am not a surety for it. And it is a company, and it does not profit. So with that information, I understand that the script goes a little different, and I understand that I have the right to let it be known that I'm not the surety, and nobody has. I'm sorry, and
okay. All right.
Yes,
So
ma'am.
Your Honor. Here's the thing. That's okay. That's not an issue. So here's the thing. I don't know if you remember when a guy named Mitt Romney was running for president some time ago. And he said, and he really upset people with this, he said, corporations are people, my friend. And a lot of people made fun of him, but corporations are people. So that LLC would be a person in the eyes of the law, but a person does not become an LLC. But regardless, we're going to read these charges because you have a right to know them. So in count 1, you are accused of police officer assaulting, resisting, and obstructing, contrary to Michigan law MCL 750.81D1. This is a felony punishable by up to 2 years in prison and or $2,000 in fines. In count 2, you are accused of assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. Lastly, in count 3, you are accused of, again, assaulting, resisting, or obstructing a police officer. This is, again, a felony punishable by up to 2 years in prison and or $2,000 in fines. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement, or under MCL 750.81D6 for another violation arising from the same transaction. And this is alleged against the peace and dignity of the people of the state of Michigan. Now, we're going to talk about your rights. You have the right to an attorney, and today, Attorney Vachon is standing by. If you can't afford an attorney, the court will provide one for you, and we have superb public defenders in this court. That said, you can hire any attorney you wish. You would have to pay them, but you could choose whomever you wish. Now, there is an option for you to represent yourself, and we'll talk about that more at a future court hearing, okay? You have the right, as this case goes forward, to have these charges heard at a trial. And at that trial, the prosecutor would have to bring evidence against you. You could question that evidence, and you could question any witnesses the prosecutor called. You could call your own witnesses. And if they didn't want to appear, the court could issue a subpoena and the court could make them appear. At a trial, you could testify on your own behalf, or you could remain silent. And if you remain silent, no one could use that silence against you. At a trial, you could bring any evidence you wished, or you could just sit there, because it's the prosecutor's job to prove guilt beyond a reasonable doubt. And perhaps most importantly, and you know this one, this is your Fifth Amendment to the Constitution, you have a right against self-incrimination. And that means no one can do anything that forces you or tricks you into making yourself guilty. Now, how do you wish to plead?
I don't. You said a lot, so can I address them part for part first?
No, not right now. So here's what I'm gonna do. Here's what I'm gonna enter. I'm gonna enter a not guilty plea on your behalf, and here's why.
Can I ask you this first? Before you enter that plea? If me giving you a plea right now, will that be in response to everything that you just said?
At this point, You'd think he might learn a lesson or two, but instead he chooses to represent himself in court, a gamble on its own. Then, making matters worse, he tries to plead guilty to 3 felonies right at the arraignment, without even bothering to review the evidence first. It's the kind of reckless move that's nothing short of a disaster waiting to happen.
Nope. So a plea would have you pleading, would have you pleading guilty to all those charges. We've got some back and forth here. It kind of sounds like we're underwater. So a plea would have you pleading guilty to those crimes, 3 felonies, without having seen the evidence against you. So you can stand mute and the court enters a not guilty plea, or you can say you want to plead not guilty and you would be not guilty. Then what happens next, and here's why, then you have a chance to get the evidence against you and to consider it. And I think that's what you want to do, because that is your hard-fought constitutional right, among other things.
It's a bit more to it, Your Honor. That's the issue. So I will, based off of the things that you stated, that's not what my understanding is. From my understanding is I was attacked by some people and I was protecting.
Sir, I know you don't want my representation, but I would advise.
No, ma'am.
I would advise that you not talk about anything that happened.
Please don't, ma'am. I appreciate that. I'm aware of where you're going at, but I'm aware. Like I said, me and the judge, I told her something that I might say could come back to haunt me. I'm already aware of that. So thank you so much, Miss Melissa, but please do not intervene. Once again, back to you, Your Honor. From my understanding, I was assaulted. And I am shoulders. Once again, I have never told anyone. Wait, I don't want you to mute me, Judge. This is going back to the situation. Okay, thank you. I never told anyone that I am Latavius Trayshawn Thornton. Not one time. I have reiterated. I am shoulders. Latavius Trayshawn, not just to you, Your Honor. That's so to be redundant for the record. Okay. I have reiterated that Latavius Trayshawn Thornton is a nonprofit organization. I am not a surety. I am shoulders. I am appointed to be an administrator for Latavius Trayshawn Thornton. No, that's why I'm here, but not a surety for Latavius Trayshawn Thornton. Furthermore, Your Honor, my understanding is I was attacked and assaulted, and I'm not sure if I could let that be known to you so that we can make that case come about, because I would like to seek forward that using the evidence from this, all the evidence that they have gathered, I would like to use it in my assault case against East Lansing Police Department and its agencies.
Okay, so we have a couple different options here. First, the court is going to enter a not guilty plea on your behalf, so you can pursue that at a hearing where we can bring in evidence and that sort of thing, okay? Secondly, you have other options. You can also, you could investigate a civil suit against the City of East Lansing Police Department. There's a police oversight commission. So those are still available to you. Right now, I'm going to enter a not guilty plea so you can get the evidence to proceed. All right. Now, next up, we have some dates when you're going to return to court. And let me just pull those up here. Okay, go ahead.
Yes, I just wanted to speak on my previous court history and let you know why it may look the way it looks.
Okay, no, here's the thing. I'm going to ask you to not say anything because I don't want to accidentally become biased.
Gotcha.
So, all right, so here are the dates. All right, you're going to come back for a probable cause conference at 8:30 a.m. March 21st. Now you're going to get this in writing, okay? 8:30, March 21st, and a preliminary exam. You're going to get this in writing too at 9 a.m. March 27th. Now, my best advice would be to speak with Attorney Vachon because she can explain how you pursue those things. Now, we're going to move on for a moment to bond.
Kind of broke up at the end. I didn't hear what you said. I'm sorry.
Okay, we're going to move on to bond or bail. So would you like to be released on bond or bail?
Could you explain the difference to me, please?
Your Honor, I was going to ask I was going to ask for a bond. People
Okay.
have,
We're going to let Mr. Anid go first. All right, Mr. Anid?
the people are looking at MCL 765.6, some of the factors to
Now you're
consider.
cutting out. I'm sorry, go ahead.
If he says something like that, would it make you biased? Couldn't you be speaking to make you biased right now?
Well, I'm going to come back to you in just a minute, okay?
Okay, no problem.
All right, Mr. Nid, I'm sorry you were cutting out, but please.
Your Honor, the people are looking at some of the factors to consider bond. The people are asking for at least a $25,000 cash surety and GPS tether if he does post bond. We're looking at the seriousness of the offense charge, the protection of the public, the previous criminal record, and the dangers of the person accused, the probability or improbability of the person accused appearing at trial of the cause. All those factors are not in favor of the defendant, Your Honor. He failed to appear for sentencing in, I believe, circuit court. And again, Your Honor, if the court has updated the lien, if you can see if he has a warrant from a couple years back, that's for pleading for attempted resisting and obstructing, is what my note indicates. Protection of the public, Your Honor. This case involves assault on officers. I think one officer got punched in the face. The previous criminal record, he has 4 criminal histories from 4 different states, Your Honor, pending from.
Okay, no, he's going to get, and then I'll hear from you, okay?
And his probably. Your Honor, lastly, he failed to appear for several years on sentencing. He's not going to appear for this case if he gets released. I just asked for a high bond and a GPS tether if he posts that bond. There's a lot of risk to the public in this case, and he obviously he has ties to Indiana, Kentucky, Georgia, and one other state, Your Honor. This is a problem.
Okay.
Thank you.
Okay, now.
Before we get to bond,
Okay, I'm going to give you a chance, but here's the thing. Because there are certain keywords, because there are specific things attorneys ask for, do you want Attorney Vachon to address this on your behalf? Because she's really good at this. I will tell you, she's really good at this.
can I say some things to Attorney Vachon before I make that determination? Right here.
Yes, Your Honor. Could we take a brief recess and I could have a breakout room?
Okay, so you're going to be in a breakout room with just Attorney Vachon, then we're going to come back. Nobody's going anywhere until after you've had a chance to come back, okay? One moment, please. We'll put you in a breakout room. Thank you.
Thank you.
The public defender steps in once more and offers her help, but he refuses yet again. Still, it seems you may have slipped him a quick pointer along the way, because for the first time, he makes a halfway smart move. He requests a personal recognizance bond.
Now we're unmuted. Mr. Anid, are you coming back?
Yes, Judge.
Okay, so I'm going to start with, Mr. Anid has spoken. I'm going to start with Attorney Vachon. Attorney Vachon, anything from the breakout room?
No, Your Honor. The defendant will speak for himself.
Whoa.
Okay. Sir, please proceed.
Okay, Your Honor. Thank you. Mr. Thornton is not a flight risk he has multiple properties in the Michigan and the Lansing area that keeps him here. Also, he has a lot of things he do here. He's a coach for 4th grade, 5th grade, 6th grade basketball teams, and they play year round. He's also a mentor to young children and to people who have had traumatic situations. They call on a daily. He's a counselor to the community and to the public. Furthermore, he's not a danger to the community or based off of his innocence, and he's not a threat to anyone in the society. He is actually beneficial Mr. Thornton is actually a beneficial role in the community, and kids and multiple different areas of people, they look up to Mr. Thornton, and they will attest to his character as an upstanding, nonviolent, peaceful individual who brings smiles and love to the community. And he, once again, may I reiterate, is not a flight risk. Yes, he has ties to other places, but those ties are not as pertinent as to the ties of where he originally was born and reside and has grown as a part of this community and in a very effective way.
Okay, thank you. That's very well said. Sounds like Mr. Thornton really has a lot of good qualities. Okay, so I am looking at the file, and I want you to bear with me a bit. There was a song when I was younger. When I was in high school, there was a popular song that said, "Cruel to be kind." Okay? So I'm looking at this, Mr. Thornton, and there's a warrant out of 30th Circuit Court, downtown, East Lansing.
Yes.
And this is from 2022. And it's a statewide pickup, no bond with extradition. So here's what I'm going to do. I'm going to come back to that in just a minute. I'm going to set a money bond of $10,000 because all of the days that you don't post that bond, you will get credit for the time. If I gave you a cash bond, what would happen is Ingham County would pick you up on this old warrant and hold you until that case was resolved. By setting a cash bond on this, you get credit for the days you're in. Then, when that's resolved or close to being resolved, I will reconsider the bond amount. We call that making a bond motion, and I'll entertain that. But right now, this is cruel to be kind, okay? I know it's not what you want, but having been around the law long enough, this means they're going to keep you in custody for some time. So I want to be sure that you get something for it.
Surprisingly, this actually works in his favor. The judge grants him a cash bond instead, which, while not exactly what he asked for, still benefits him by giving credit for the time he's already served, all while a separate warrant continues to hang over his head.
What would you like to say?
First and foremost, how much you said that for each day that the bond isn't posted, there would be a credit amount. I'm not. I just want to throw this out there for Latavius Thornton. Once again, he accepts that offer for the credit amount to be $1,000 a day, and furthermore, he accepts other offers from the prosecuting attorney's office if they are willing to go day by day with Mr. Thornton, if he's incarcerated.
Well, that's good to know, but that's not on the table just yet, okay? And so what happens is you get credit for time, in this case, with that bond amount. Otherwise, if I were to give you what's called a PR bond to say you can go, then you wouldn't get any credit for this time while you're waiting for that old case to be resolved. So, okay. So you're going to receive all of this in writing, and we will see you back 8:30 a.m., March 21st. Okay. And you want to discuss with Attorney Vachon what a probable cause conference, or Attorney Foreman.
Your Honor.
Yes, ma'am.
There was no application for public defender submitted. So at this time, there will be no counsel with him. Now, if Mr. Thornton changes his mind at any point, he can always apply for the public defender's office. But at this point, I'm unable to submit an application for an attorney.
Okay. Well, I would just ask you to consider. Here's the thing. You can apply for it and turn it down later. But if you don't apply, it can stretch things out a lot longer, and you don't want that. Just worth considering. You make your own decision. You certainly have every right to make your own decision, but I would just, if my beloved baby nephew, who's not a baby, he's about your age, we're in this situation, that's what I'd suggest to him, okay?
Here's a bit of free advice. If a judge takes the time to give you direct legal guidance, it's probably wise to listen. That concludes the first hearing. Moving into part 2, our self-proclaimed sovereign citizen remains determined to play the role of lawyer, even though it's painfully clear he's in far over his head.
We are on the record in the matter of People versus Latavius Trishad Thornton. This is case 25-0203-FY. May I have appearances for the record, please? Mr. Inez?
George, thank you, Honor. George Nidabad for the people.
Thank you. And Mr. Thornton, could you state your name for the record, please?
I am Shoulders in here by way of executive office for Latavius Trishad Thornton nonprofit organization.
Accept that as Mr. Thornton announcing his appearance before the court. We are here this morning for a pre-exam conference Mr. Anid, it is my understanding that Mr. Thornton has declined representation. However, Mr. Thornton, at every appearance, I need to remind you that you have a constitutional right to be represented by an attorney, and that if you can't afford an attorney, the court will provide one for you. I am particularly proud of the superb public defenders we have in this court. However, you may also retain any attorney you wish. You will get to choose the attorney. You would have to pay them. You have a constitutional right to represent yourself, but I have to warn you that if you proceed representing yourself, you would be held to the same standard as all attorneys who have gone to law school, passed the bar, and been admitted to practice. So the court really can't give you any breaks or help you at all. Is it your wish to represent yourself, sir?
Mr. Thornton is aware of the courtroom decorum and the standards and procedures that must be upheld by a person in representation of a party. And as again, I shoulders, I am aware that I do have constitutional rights, not just the ones that were mentioned here before, and also that the exercising of a right is also an expression of a right, which is an invoking of a right, which is a way that a right can be used, and to uphold the proper standards. Mr. Thornton does not wish to get public counsel representation as I am a legal representation by special appearance through the executive office for Mr. Thornton and not the actual entity, Latavius J. Shaw Thornton. Once again, on the record, it has not been declined that Latavius J. Shaw Thornton is a nonprofit organization, which, yes, Your Honor, is a person, in fact.
Yes. We've all heard 100 times by now. You're a so-called person, in fact. But here's the only fact that really matters. You're still sitting behind bars.
And I, the man speaking with a voice and a sound mind.
So I'm going to cut this off. I don't want to mute you, but we have to move forward. So we have an attorney standing by. That would be Mr. Foreman, who is a very, very good public defender who is available to you. At this point, Mr. Anid, this is the time and date set for a pre-exam conference. Have you had an opportunity to speak with Mr. Thornton about any plea offer?
No, Your Honor, and I don't think I'll have any meaningful conversations with him based on what I see. I believe that it's not clear whether what he's doing is intentional or whether this may be a competency issue. But I'm prepared to proceed. I just don't know if we should. I have a concern for his competency, to be honest with you. If the court we had the same issue this time.
No, Mr. Thornton, one person at a time. And right now, Mr. Anid is speaking.
I mean, I guess I would inquire with whether he knows what a preliminary exam is, and if he understands, if we forward, if he's gonna know what to do. I mean, I believe I have to look at the court rules. I've never dealt with this issue, but I think having standby counsel would be something that would be needed to advise him. I'll look into all that, but I just don't know if he's gonna know what a preliminary exam is. I believe this may just be a competency issue. I don't know, Your Honor.
Okay, so actually that's a good question. So Mr. Thornton, I'm going to ask you, what is a preliminary exam?
Well, before I address that, may I address
No,
it to
sir. No, we're gonna focus our answers here. What is a preliminary exam?
Your Honor.
I'm going to give you one chance to answer. What is a preliminary exam?
A court proceeding.
Okay, and what happens? That's a good answer. What happens at that court proceeding?
At a preliminary examination court proceeding, the parties have the opportunity to present evidence, cross-examine each other, and determine whether evidence is admissible to go into continual proceedings, whether the court has jurisdictions. A plethora of matters may be brought up in a preliminary examination to see if the court has a valid standing, to see if there's anything, to see what may be addressed that's necessary as far as the parties that are at hand, not only to go about things in a one specific fashion.
Well, that's pretty that's a pretty good answer. However, at this point, given a review of
Your Honor,
history, the court is going to sua sponte suggest that a competency exam be ordered. Mr. Anid,
I
any
agree.
response?
I agree.
Okay, thank you. Mr.
Yeah.
Thornton, any response?
Mr. Thornton does not believe that a competency exam sua sponte is necessary and objects that as a preliminary exam is something that we can proceed to and we can address the matters and the situations that are necessary at that time. And for the sake of due process and the judicial precedence of due process, that a criminal or a competency test may delay that, and it could hinder not only Mr. Thornton, but the things that Mr. Thornton does as far as the community and his career and his family and his life and rights, and other people that may be affected by this matter, as well as the public. Because for the judicial precedence is that Mr. Thornton is innocent and not guilty.
So, Mr. Anid, are you going to prepare a proposed order, or?
Your Honor, I think it's been a while since I've done. I believe if I'm not mistaken, it's the. I can if you want. Yes, I'll prepare an order.
All right. So, at this time, Mr. Anid, comment on the preliminary exam?
No, I just say we just make the preliminary examination to be determined date. If anything, reset it for another PCC or review hearing for when we do come back with a competency opinion.
Okay. So, Mr. Thornton, you have two rights at play here. One is the preliminary exam that we just discussed, and the second is the right to have that within 21 days. So, the reason that you have a right to have that within 21 days is to prevent cases from dragging on endlessly. There are certain timelines that have to be met. However, the court can waive that 21 days if it finds good cause. And that would be, for instance, if one side had recently received discovery and was unable to proceed. Another good cause could be if someone was ill or hospitalized. There could be any number of good reasons. So I'm going to ask you, actually, Mr. Thornton, have you received any discovery in this matter?
I have not. Mr. Thornton has not received any instrument.
Okay, so, all right, two things then. First, I find good cause to waive the 21-day rule, and we will get a date. No, sir, just a minute. Let me finish. You can't, you don't, no, listen, I don't want to mute you, but I have to get through this. So, you have to have, you have a constitutional right to have knowledge about your case. And if you haven't received any discovery, we can't go forward until you receive it. So two things. First, I'm going to waive the 21-day rule. And just a minute, Mr. Sid. We're going to waive the 21-day rule, and we're going to set a date out in about a month. That'd be a placeholder date. And for a moment, at Mr. Anid's request, the court, Mr. Foreman and Mr. Anid discussed standby counsel. So standby counsel is something with certain mechanical concerns. So for standby counsel, the court can't just appoint standby counsel. This is what we discussed in the breakout room. The court, or perhaps its funding unit, the City of East Lansing, would have to enter into a contract with the Public Defender's Office. And if both sides agreed to that and a certain financial rate, then an attorney from the Public Defender's Office would sit next to Mr. Thornton and be available to advise him during all proceedings. Back in the day, when I was on the court appointed list, a judge could just appoint someone and do it. That doesn't exist anymore because of the MIDC. So we discussed the mechanics of that. The court is going to make a formal discovery request on behalf of Mr. Thornton. So, Mr. Thornton, you should receive at the jail, or if you post bond at the address we have on record, all of the materials that a defense attorney would receive that the prosecutor has. At this point, Mr. Enid would like to speak with Mr. Thornton and perhaps see if a plea deal is possible. So, Mr. Thornton, you never have to accept a plea deal, but it's worth listening for two reasons. First, there may be something there that you can reach an agreement on. You have a constitutional right to have these charges heard at a trial. Sometimes you can make a bargain, something that is worth giving up your right for a trial, for instance, a lesser charge, a lighter sentence, or both. The other side is you kind of want to know what the prosecutor's thinking about the case. So as a defense attorney, I always wanted to hear what the plea offer was. Even if my client was absolutely not going to take it, it gave me some insight into where the prosecutor was interested in going with the case. Again, you were never required to accept a plea bargain. At this point, because you are representing yourself, I'm going to allow you to converse with Mr. Enid, recognizing that you do not have discovery materials, so I do not expect this court to accept a plea bargain today. All right. We're going to put you both in a breakout room, and when you're done, the court will be ready. Thank you.
Now we move forward as a prosecutor and the defendant step into a breakout room to discuss a potential plea deal. But the real story comes when the prosecutor returns. One look at his face is enough to tell you everything you need to know about how that conversation went.
Okay, sound is back on at the jail, so we will go back on the record in the matter of People versus Latavius Rashad Thornton. This is case 25-0203-FY. Mr. Enid, prosecutor, and Mr. Thornton, representing himself, have met in a breakout room. So first, because the prosecutor has burden of proof, I'm going to ask Mr. Enid first, then Mr. Thornton, I'll ask you. So Mr. Enid, anything from the breakout room that you'd like to report?
Yes, I just want to make sure Mr. Thornton is there because I don't see him on here.
Oh, I see him.
Okay. Can you hear me? Okay. Yep. So we discussed. Yep. We discussed a little bit of as much as we could. I believe based on my discussions with him, I don't believe this is a competency issue. I believe this is more of the what Mr. Thornton kind of described earlier. So the plan, I think we both agreed on, is we're asking for another probable cause conference. I'm going to somehow figure out how to provide him discovery, the complaint, the information, all the charging documents that we have. We're going to come back. In the meantime, I'm going to do my due diligence to speak with our office to see how we're going to go forward with this. Because I know it's my understanding he wants to represent himself. That is his right. I believe based on the questions that you asked earlier, he answered them pretty fairly, Your Honor. I just want to make sure we got all ducks in order. I discussed a misdemeanor offer potentially with them, but also discussed that I encourage him to get a public defender. All these things I think we're going to discuss at the next probable cause conference. I think these are all appropriate matters so I can get my ducks in order. He can have discovery to know what he's looking at. And I believe at the next hearing, we will have a good understanding of what we're doing going forward.
Mr. Thornton, is that an accurate report?
It's pretty accurate, Your Honor. Just a few more points that we had discussed in that breakout room was also that it was in the discovery, we would like to get subject matter in the appointment of the authorities that has been filed onto the record for these proceedings and how we came about to be into the court's jurisdiction for this matter in such fashion. And I think that's kind of
that's a word salad. It's not making any soup. Can you any sense at all? Can you rephrase that for me, Mr. Thornton?
Okay.
So just pretty much all in the discovery, we didn't want any documents that have been filed onto the case to be missing. And that's that's what I mean by not limited to the documents titles that he named. It include an inclusion of all documents filed with all titles under them.
In short, he's demanding the impossible. Signed oaths of office, credentials from the King of England, proof of jurisdiction, maybe even someone's firstborn child. And while he's at it, a drop of blood too. It's completely absurd, but unfortunately, this kind of nonsense is all too common when it comes to sovereign citizen cases.
Yes, Mr. Ned.
And I think kind of what he may be talking about is, and I could be wrong, is the charging documents, what gives us the authority to proceed forward and how we're proceeding forward. And I explained you should wait until you discover it because I believe that's going to be the complaint, the information, and the other charging documents to see where we're at. I could be wrong, but once he receives those, we'll come back. We'll have all the ducks in order. I think that's a good resolution we both agreed on. And in the meantime, I'll do my due diligence to speak with our officer how we're going to go forward. I told Mr. Thornton, I'm the prosecutor. He understands what the prosecutor is. I'm not on his side, but I did advise I'm here to help get the situation resolved as fast as possible. And I think we both agree that if you find good cause to adjourn this for one more probable cause conference, I believe everything will be situated. The only thing I have to ask is how do I provide discovery to Mr. Thornton?
I would guess that you could mail it to him or, yeah, I think.
I'll figure it out. I'll ask my office.
Communication through the jail.
Okay.
At his address through the jail, and it may have to be paper communication.
Okay. I'll do my due diligence today when I get to the office today, Your Honor.
Okay. And yeah, I don't have discovery demand in front of me, but that would include, of course, any exculpatory materials granted under Brady. That would include make a request for any body-worn camera, any evidence you plan to introduce, any car video, any report that you have in your office other than was protected under attorney-client privilege with a prosecutor or any counsel. Mr. Thornton, anything further this morning?
Not at this time, Your Honor.
Just new dates, Your Honor. New dates. New probable cause.
Okay, so we had the dates, and that is 8:30 a.m., April 25th, for a probable cause conference, and 9 a.m., May 1st, for a preliminary exam.
Okay, so the next probable cause conference is about a month away. Does that sound right?
Yes.
Okay. All right.
So, Mr. Thornton, if at any time you change your mind, you can communicate with the court and or Mr. Anid about requesting counsel. At every hearing, I'm obligated to tell you your right about counsel and to determine the parameters of that. All right, so we will see you back at 8:30 a.m., April 25th. That is all.
Thank you, Your Honor.
Thank you.
Take care.
Thank you.
Take care, Mr. Amid.
Thank you.
And that's where we'll wrap things up for now. Normally, I'd hold off until more hearings played out or the full story unfolded, but this might be the last real update we get. With a plea deal already on the table, there's a chance he might take it. Still, knowing his track record, it wouldn't be surprising if he rejects outright and keeps leaning on his imaginary legal team, shoulders, knees, and elbows. And if that happens, don't be shocked when it only earns him even more time behind bars.